Okay, let me back up. Okay, now the arraignment that we have here set today, as I said earlier, your case is classified as either a misdemeanor or a felony, Class A misdemeanor or Class B misdemeanor. If you have a Class A misdemeanor, the range of punishment can be confinement in the county jail for a term not to exceed 1 year, which is 365 days, or you could be given a fine not to exceed $4,000, or you could be given both such fine and confinement. If it's a Class B misdemeanor, confinement, the range of punishment is confinement in jail for a term not to exceed 180 days or 6 months, or you could be given a fine up to $2,000, or you could be given both such fine and confinement. Now, with that range of punishment, uh, it goes from 0 days all the way on up to a year for a Class A misdemeanor, anywhere in between. A fine $0 to $4,000 or anywhere in between. For the Class B misdemeanor, confinement from 0 days all the way on up to 180 days or anywhere in between. A fine to up to $2,000, from $0 to $2,000 or anywhere in between, or you could be given both such fine and confinement. And as I said earlier, you may qualify for what we call probation. There are two types of probation. One is called deferred adjudicated probation, and the other type of probation is the unadjudicated or the regular probation. And the difference between the two, with the deferred adjudicated probation, it does not result in a conviction on your record. With the adjudicated probation, it does result in a conviction on your record. Now, even if you have a conviction on your record with the adjudicated probation or the regular probation, there's something that is called judicial clemency, which means that the court can set aside your conviction, and if you qualify, and the way you qualify is you have to successfully complete the probation, you have to be discharged off the probation, and the probation has to expire. And those three things happen. The court can allow you to come back in the court to withdraw, which means to take back your plea. And if that happens, then the court can set aside the conviction, and any complaint, affidavit, or information that has been filed against you will be dismissed. And the conviction is, once the conviction is set aside, you will no longer have a conviction. However, if you violate the terms, well, if you get a subsequent conviction, another conviction later on, then this case can be brought back up, resurrected, or revived and used against you. Now, with the deferred adjudicated probation, which does not result in a conviction on your record, your case is dismissed and you may qualify for non-disclosure. However, if you violate the terms and conditions of your probation, then the court can, the district attorney can file a motion to revoke your unadjudicated probation. And if that happens, you'll be arrested, brought back into court for the court to have you have a right to have a hearing, and the court will have a hearing to determine whether or not you violated the terms and conditions of your probation. If the court finds that you violated the terms and conditions of your probation, then the court can, at that time, revoke your probation. And if your probation is revoked, you can get a conviction. And if you get a conviction, obviously the case is not dismissed and you cannot qualify for a non-disclosure. Now, you have a right to have an attorney, and there's a form that you was passed out earlier. On that form, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that form, it says defendant's choice. Mark initials to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the line, on the first line to the left. If your choice is, I have hired an attorney whose name is, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If your choice is, I have a court-appointed attorney whose name is, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. And once you have finished placing your initials on one of the 5 lines, you will sign where it says defendant and write today's date, January 26th of 2021. Now, for those of you who initials, I want to waive my right to an attorney and represent myself, you will also have to sign the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 26th day of January 2021 by a county court at law, number 2, of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that says defendant, and you will put today's date, January 26th of 2021. Now, if you are not a U.S. citizen, on a plea of guilty or nolo contendere, it may result in deportation, which means you could get kicked out of the country, exclusion from admissions to the country, which means if you're outside the country trying to come in, they could prevent you from coming in, or denial of naturalization under federal law, which means that if you file an application to become a citizen, they could deny your application. You also have a right to have a trial by jury. And what I mean by trial by jury, in the area over there, we call that the jury box. There'll be 6 citizens who will be selected to sit on the jury, and they will listen to the evidence in your case, and they will decide after listening to all the evidence whether or not you're guilty or innocent. You have a right to waive or give up that right to have a trial by jury as well, and just have your case come before the court, either by what we call a bench trial, that's a trial before the judge without a jury, or through what we call a plea. If y'all have a plea bargain agreement, or if it's an unagreed plea, you can come before the judge only to make that decision. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair over there. We call that the witness stand. They can testify either for you or against you. You have a right to ask them questions. We call that either direct examination or cross-examination. If you do not want any witnesses to, if you do not want to call any witnesses to testify in your case, you have a right to waive or give up that right to have witnesses that you're going to call in your case. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state has against you. If you would like to see that evidence, then the state can allow you to have access to that evidence. If you do not want to see that evidence and you want to waive your right uh, to discovery, you can just simply sign a waiver saying that you do not, that you would like to waive your right to discovery. Now, also, for those, if you have a lawyer or if you're representing yourself, they'll have an opportunity, or you'll have an opportunity to talk to the prosecutor and to see if y'all can work out what we call a settlement. Is normally referred to as a plea bargain agreement between the defense and the state. The state is the district attorney. If you are able, if you are able to work out a settlement agreement or plea bargain agreement, the court does not have to follow that agreement. The judge does not have to follow that agreement. If the judge does not follow that agreement that you have worked out with the state, then you can withdraw, which means you can take back your plea. Also, now, if you're not able to work out a plea bargain agreement with the state, you have an option to maybe just come before the court on what we call an unagreed plea, or you could just simply set your case for trial. Now, if you are able to work out a plea bargain agreement, and if the court follows that plea bargain agreement, and if you decided within 30 days that you have been wrongfully convicted, or the court committed an error by convicting you, and you would like to appeal your case, what an appeal is, you would like to have a higher court to look into the case. They would, and we call that an appeal. You're appealing it up to a higher court so that they can look into your case. And the way that works is, if the judge follows the plea bargain agreement, you have to get the court's permission to appeal. Now, if he didn't follow that plea bargain agreement, and it states here that if the judge granted you permission, then you'll have a right to appeal. Now, if it is not a plea bargain case, then the defendant has a right to appeal. If your case is appealed, your case will go up to, well, in this county, it's the Ninth Court of Appeals. They are right above us on the 3rd floor. They will review your case. They will determine whether to grant or deny your appeal. If they grant your appeal, then they can either find you not guilty and you'll be acquitted, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you'll have a right to appeal it to another court, to a higher court than them. That court is called the Texas Court of Criminal Appeals. It's the highest court in the state of Texas. It's located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means without a lawyer. You'll be doing it on your own. Now, if you're pro se, you file a pro se petition, the Texas Court of Criminal Appeals can either grant it or deny it, your pro se petition. If they grant your pro se petition, they can find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. If they deny it, then at that point, your conviction will stand. Now, in Jefferson County, there's a program that is called pretrial diversion. It's ran through the district attorney's office. And what that program is designed to do for people who have not been in trouble before, it's designed to your case will be, you'll be put into a program, your case will be dismissed, and you can get it expunged from your record. Expunged means erased, deleted, or wiped out from your record. Now, in order to qualify for that program, One, you have to get a lawyer to assist you to get into the program. Two, it cannot be an offense involving unlawful carrying a weapon or resisting arrest. And three, you cannot have a criminal history. It has to be your first case. Now, as I said earlier, if you get into the program, the case is dismissed, you complete the program, you can get it expunged from your record. That's through the district attorney's office. Now, if you are a veteran of any one of the branches of the military, there is a program that is called Veterans Court. It is also part of the pretrial diversion program. You get into that program, go through Veterans Court, your case is dismissed, then you can get it expunged, which means erased, deleted, or wiped off from your records. That's for veterans. This court has a program that is called the CSI program. That program, CSI, stands for Community Safety Initiative. It is a program that is designed to address the problem of recidivism. Recidivism is while people are committing crimes over and over. And the way we address that is by making Jefferson County a safer place for all of us to live, work, go to school, raise our family, go to church. And so through that program, we have partnerships. We have partnerships with Spindletop, MHMR. We also have a partnership with Spindletop. They have a program, a drug and alcohol program. And we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. Lamar University has a program called CICE. It's a job training and a job placement program. Now, the way the program works with Spindletop, we have a mental health officer as well as a counselor in court. They can give you private interviews, do an assessment, and develop a treatment plan, either outpatient or inpatient, and address whatever mental health needs that you have. Now, if you have an issue with drugs or alcohol, Spindletop has a program called ATAR for individuals 20 years old or younger. That's the youth program. And the OZAR, which is a local drug and alcohol council, can come in and do a private interview or private screening assessment and develop a treatment plan, either outpatient or inpatient, as well to address your problems that you may have with drugs or alcohol. Now, with the program with Lamar University, or with the Golden Triangle Empowerment Center and the CICE program, which stands for Center for Innovation, Commercialization, and Entrepreneurship, they can provide you training in the hotel industry, the shipping industry, or the chemical industry. Once you get training in those areas, they will assist you with getting employment in those areas. Now, the good thing about that program is they will, you getting into the program through, not just getting in the program, but getting into the job through their relationships that they have with the various companies that's in the area. So, for example, if you may try to go and they may not let you in because of various different things, but because of the relationship that they have with CICE, they may let you in. And so that's how the program works. So it's through that relationship that they have with the companies in this community, and because of the training that they provide for you, they can get you in the doors that you can't get in yourself. Okay. And so that's the good thing about that CICE program. Now, if you need a GED, if you haven't finished high school, Spindletop has a GED program, and I think CICE has a GED program. All of those programs that help so that you can get a better job and so that you can be more productive. And that's what the program is designed to do, is to make productive people. I tell people this all the time. When you come to county court at law number 2, we don't just have court as usual, we have unusual court. And the reason why I say we have unusual court is not because we're different, but because we're trying to make a difference in Jefferson County, and we're trying to make a difference in the lives of the individuals that come before this court. All of the programs that I just spoke about, all of the programs that I just mentioned are free. It does not cost you anything. Only thing that you have is just take your time, and they'll help you with dealing with whatever issues you have, educationally or mental or drugs or alcohol or employment. All of these programs are designed to produce productive people. And if we produce productive people, for the most part, productive people do not commit crimes, okay? Now, the other thing is, if for every day, now everybody here has been arrested on their case. And every day that you spent in jail, that jail time can go towards your punishment. If you have a fine and court costs, every day that you spent in jail is considered $100 per day that can be used toward your fine and court costs. So for example, let's say you have a fine and court costs of $500 and you spent 5 days in jail. That's $500. You won't have to pay anything. Why? Because you've already spent 5 days in jail. Or if you spent 5 days in jail and the punishment is 5 days in jail, you won't have to go to jail. Why? Because you'll be given credit for time served because you've already served 5 days in jail. All right. So the other thing is all of the programs that I just mentioned could be used as community service. And I'll explain that just a little later. If you cannot pay your fine and court costs, we could put you on a payment plan. You could pay it off in monthly installments. But let's say you can't pay it off at all. Then we can convert your fine and court costs to community service. Every hour that you work on community service, you get $12.50 that will go toward your fine and court costs. All right. Now, all of the programs that I just mentioned through our CSI program, that means the mental health program, drugs program, the alcohol program, the job training and job placement program, the GED program. All of those programs can be used as community service. So for example, I tell people this all the time, you could kill 3 birds with 1 stone. I know people say 2 birds, but you can kill 3 birds with 1 stone. And what I'm gonna explain that to you. If you order to pay a fine and court costs, but you don't have the money, we converted it to community service. That's the second thing. And let's say you have an issue, you're working on your GED. That's the third thing. While you're in the GED class, you paying every hour that you work goes toward community service, and every hour, $12.50 is going to be credited toward your fine and court costs. So if you got a drug problem, or if you're looking for a job, and you're getting job training, or if you have a mental health issue, or if you have an alcohol issue, all of those programs can be used as community service. And every hour you are in one of those programs, $12.50 is going to be contributed toward your fine and court costs, and 1 hour, every hour goes toward your community service. So that's why I say you kill 3 birds with 1 stone. And that's why I say that with this program, we don't just have court as usual, we have unusual court, because we are not trying to, we're just trying to make Jefferson County a safer place, okay? Now, we have someone here from Spindletop, Deputy Hinton. He's our mental health officer, and he's gonna tell you some things about the Spindletop program, and it's the program is very confidential, and is not just confidential, it's beneficial for those who participate, okay? At this time, I'll turn it over to Deputy Hinton.
Good morning.
Good morning.
My name is Steve Henn, I'm a mental health deputy with the Jefferson County Sheriff's Office. I have my partner here in the back room, Ms. Lawless. She's with Spindletop. The sheriff created a program called ASAP, where the sheriff's department and Spindletop go together, and we go out in the field, we go to the court systems, we go to the jails, and we try to help people who are having mental health issues. Sometimes what we find is when there's mental health issues, sometimes there's repeat occurrences in the jail, which ultimately results in the criminal justice system as here. Now, this may apply to you. It may not apply to you. You may have family members that you could benefit from it. Again, this is a service that's free. We're willing to talk to you about it. It's confidential. And as the judge says, it can be applied towards some of your costs on your court proceedings as well as your participation in the services. So as the court proceeds, I'm going to be just interviewing, talking to every one of y'all, and just kind of touching base with you, see if this is something that you'd be interested in. And we can speak back here in the back privately. Again, it's HIPAA regulated. We're not going to discuss with anyone else. This is extremely private. And we do that for the benefit of y'all. We're here to advocate for you. If you choose to use the services, then obviously we will advocate. We'll walk you through the services. Sometimes it can be kind of complicated and complex. Through Spindletop, we're there to help you if that's something that y'all would be interested in. That's what we want to do. I want to thank the judge for graciously allowing us into his court system to be able to be here for y'all. Obviously, he has a heart for the people, and we want to assist him in helping y'all. Anybody have any questions? Okay, good deal.
Okay. All right. Now, just all of the programs that we talked about, they're free. Only thing you can just have to say, but Judge, you know, I want to participate in one of the programs, and then we'll have somebody to talk to you in the back. And it's private. If you want to, like I said, if it's job training, we can talk to you in the back about that. So whatever it is, it's going to be private and just between you and the court. But as I said earlier, these are the programs that we have. We call it the CSI program, stand for Community Safety Initiative. Okay. So at this time now, we handed you out those forms. If you finish filling out the forms, then our bailiff is going to pick them up, and then you're going to fall into maybe one of the three categories. Either you want to hire an attorney, you may qualify, or want to see if you qualify for a court-appointed attorney, or you want to represent yourself. So you're going to fall into one of those three categories. If you haven't filled it out, take the time to fill it out. And as I said earlier, that second page is only for individuals who will be representing themselves. They're waiving their right to an attorney and they want to represent themselves. That's when you fill out the second page. If you're not doing that, you don't have to fill out the second page. Okay? All right. So we'll be in recess and so we can look at the forms. Now, the other thing is, for those of you who want to see if you qualify for a court-appointed attorney, you're going to have to fill out a financial questionnaire. We have those forms in court, okay?